Okay, let's jump right in. In this explainer, we're going to unpack a massive societal clash over post-apartheid land restitution in South Africa. And honestly, we're going to see how it actually played out in the courtroom. We're looking at a deeply complex moment in legal history. It's where the grand, sweeping ideals of a brand new democracy collided head-on with the strict, rigid rules of legal procedure. It's the 1996 Constitutional Court case, the Transvaal Agricultural Union versus the Minister of Land Affairs.
So here is our docket for today. First, the promise of restitution. Then, the farmer's legal challenge, skipping the legal line, balancing competing rights, and finally, the final verdict. Section 1. The promise of restitution, correcting historical dispossession. To really grasp the stakes of the 1994 Restitution of Land Rights Act, which, by the way, was mandated by the Constitution to return land rights lost to discriminatory laws, we have to look at the sheer scale of the goal here. 2 million. That's the estimated number of people potentially affected. 2 million. The source material notes that over 10,000 claims had already been lodged at the time of this specific case, and everyone expected that number to double. I mean, the administrative burden alone is just astronomical. The Commission on Restitution of Land Rights was staring down a completely monumental task. They were legally obligated to investigate an 80-year history of displacement. We're talking claims stretching all the way from June 1913 to April 1994. Just imagine trying to untangle decades of property records, family histories, and shifted community borders. It was a legally and emotionally charged mandate, literally designed to bring justice to communities systematically uprooted. Moving to Section 2, the farmer's legal challenge, the pushback. Look, whenever there's a massive shift in property dynamics, you're going to see some pushback. The Transvaal Agricultural Union, who represented current landowners and farmers, brought a direct challenge to the Constitutional Court. Now, to be clear, they didn't object to the idea of restitution in principle, but they absolutely objected to how the mechanics of the law were actually hitting their farms. Here's why. The Act laid out a specific process. Step 1, a claim is lodged. Step 2, if the regional commissioner says this isn't frivolous, they publish a notice in the Government Gazette. And Step 3, this is the real flashpoint, the second that notice is published, certain property rights are totally frozen. The landowner suddenly can't evict a claimant living there, and they can't destroy or remove improvements on the land without special written authority. So the farmers took massive issue with their rights being restricted the very minute a claim was gazetted. Which brings us to a really foundational legal concept, audi alteram partem. It literally means listen to the other side. The farmers argued they were completely denied this basic administrative right. Their whole point was, hey, before the commission publishes that notice and effectively freezes our land rights, we, the registered landowners, should get a hearing. They felt the state was just locking down their property without giving them a chance to speak first. So, what we have here is this epic, incredibly high-stakes clash. In one corner, you've got the claimant's constitutional right to land restitution under Section 121. In the exact opposite corner, you've got the current landowner's constitutional right to property and free economic activity under Sections 28 and 26. How on earth does a society balance the need to correct a massive historical injustice with the existing legal rights of property owners? That is the heavyweight constitutional question here. All right, Section 3, skipping the legal line, the procedural twist. Just when you expect this landmark sweeping ruling on exactly who owns the land, we hit a massive plot twist, and it's centered entirely on legal procedure. The Farmers Union actually filed their case directly with the Constitutional Court. They tried to bypass the Supreme Court entirely to get immediate relief from the highest court in the land. It's kind of like trying to skip a grade in school. In the legal world, the Constitutional Court is generally your court of last resort, right? Not the place you just walk up to and start your lawsuit. And Constitutional Court Rule 17 shows just how strict that barrier for direct access really is. It says you can only do this in exceptional circumstances where delays would prejudice the public interest or the ends of justice. You can't just walk through the front doors because you think your case is super important. You've got to prove absolute exceptional urgency, like a true hair-on-fire emergency. And the burden of proof was entirely on the farmers to show that. But when the court actually looked at the timeline, the farmers' argument for an extreme emergency kind of just fell apart. The court pointed out some pretty crucial facts. The 1994 Act was passed with plenty of public comment, and the union hadn't raised any initial objections to these provisions. In fact, they waited 17 full months after the Act passed to even file the lawsuit. 17 months!
Furthermore, out of the 648 notices that had already been published, the minister noted there were exactly 0 actual requests made by landowners to evict claimants. So waiting a year and a half while suffering 0 recorded actual prejudice, that completely destroyed the claim that they needed to skip the line.
Section 4. Balancing competing rights, the court's perspective.
So even though the case was failing pretty hard on procedure, the court, led by Judge Chaskelson, still took time to give some really vital constitutional guidance on how these competing rights actually have to be balanced. The Constitution demands this really complex, step-by-step balancing act to make sure resolving these claims is just and equitable for everyone. It is not a zero-sum game. You have to acknowledge the legitimate claim, heavily weigh the history of dispossession and hardship, but you also have to consider the current landowner's interests. And if restitution is granted, the state steps in to either purchase or expropriate the land. It's a deeply nuanced framework. The court also impartially clarified a really vital principle here. Existing rights of ownership do not automatically have precedence over claims for restitution. They pointed out that temporary freezes on property, stopping evictions or the destruction of improvements, serve a highly legitimate purpose. They're designed to protect vulnerable claimants and just maintain the status quo while the incredibly complicated legal gears are turning. And crucially, this property freeze wasn't a total dead end for the farmers. They always had a safety valve. If a farmer desperately needed to make an improvement, or they actually had a highly justified reason for an eviction, they could apply directly to the Chief Land Claims Commissioner to get written permission. So the actual interference with property rights was deemed relatively slight, simply because a mechanism existed to ask for exceptions. Which brings us to Section 5, the final verdict, process over rules. Here is the final unanimous judgment of the Constitutional Court. First, the farmers totally failed to establish exceptional urgency. But more importantly, the justice system demands that you follow the proper steps. The whole question of whether the farmers had a right to be heard before the Gazette notice was published, that's a question of statutory interpretation. And the proper place to interpret a statute is the Supreme Court. You have to go there first. Because the interference with their rights was deemed slight and there was no real emergency, the application for direct access was just completely dismissed. Because, look, skipping the line has consequences. The farmers ignored ordinary procedures and took a gamble on direct access without the urgency to back it up, and they were penalized for it. They were literally ordered to pay the heavy legal costs for these abortive proceedings, including the costs for 2 counsel. It is a really stark reminder that in the realm of constitutional law, procedure is absolutely not just a suggestion. It is the strict rule of the game. So I want to leave you with this provocative thought to chew on. When massive historical injustices meet the strict rules of the courtroom, which ultimately shapes our society more? Is it the grand constitutional principle, or is it the rigid legal process? We often think of the law purely in terms of sweeping justice and grand rights, right? But as this explainer clearly illustrates, even the most high-stakes, emotionally charged historical conflicts are ultimately managed, filtered, and sometimes even halted by the cold, rigid mechanics of legal process. It really makes you wonder. I hope this breakdown helped clarify exactly how these vital constitutional mechanisms actually work in practice.